Today we want to talk about what the Section 60I certificate is. Hi, my name is Evgeny. I'm a family lawyer and I'm also a mediator. I'm a family dispute resolution practitioner. Now, Section 60I certificate is a certificate which is issued by a family dispute resolution practitioner, by a mediator. Where is it coming from? Generally speaking, Section 60I of the Family Law Act says that if parents have a disagreement, parenting dispute, people separated, they can't work out the parenting arrangement about the children, they should try mediation. And if this mediation doesn't work, the mediator can issue a Section 60I certificate, which looks like this. It's a one-page document. Now, this requirement is compulsory, so people can't just go straight to court unless it's urgent to ask the court to assist with their parenting dispute. They need to go to mediation, and this is what Section 60I of the Family Law Act provides for. Now, there are a few types of Section 60I certificates, and the type of a certificate you would get if your mediation fails is going to be one of those here. Now, let's talk about these 5 types of certificates. Now, the most common probably is Certificate A. Certificate A is issued when the mediation hasn't happened for some reason. Now, let's say party A, mom or dad, would approach a family dispute resolution practitioner, a mediator, conduct an intake session, and the mediator would write to the other party inviting them to participate in the process, to participate in the mediation. And this other party might just say, no, it's too expensive, or I don't like you as a mediator, or I try to do other venues, I try to do it through lawyers, I try to do it through other mediation services, or I try to resolve it directly, or they might not even respond. In this case, the mediator may be asked to issue a Section 60I certificate stating that the other party failed to attend. Now, that's probably the most common. The second certificate is Certificate B. Now, Certificate B is when the family dispute resolution mediator, family dispute resolution practitioner, determines that the matter is not suitable for mediation. Now, this matter is quite rare. From my experience, I think I did it once when the matter was not suitable for mediation, usually when it's severe domestic violence, disbalance of powers, or other issues. There is a legal requirement for us as family dispute resolution practitioners to do this determination, whether these people, this father and mother of the child or children, can mediate their matter, and what safeguards should be in place to do so. And usually the majority of mediations the majority of matters they are suitable for mediation. Now, the third certificate is Certificate C. Now, Certificate C is where parties attended the intake appointments, parties attended mediation, they made a genuine effort to resolve the disputes, maybe all issues or one particular issue, but they could not resolve all of them, or could not resolve a particular one. So in this certificate, the mediator would say, the parties attended with me, they've made a genuine effort, but they couldn't resolve all the disputes. Now, the next step would be issuing certificate. The parties might wish to go to court, the parties might wish to try mediation or any other options to resolve their dispute. So the certificate by itself does not trigger the court action. So it's another big misconception about that. People think, oh, I got a certificate, I need to go to court. No, you're not obliged to. You can within 12 months of the date of the last attempt at mediation, right? So this certificate is valid for 12 months from the date of last attempt. Within these 12 months, you can initiate court proceedings and need to attach a certificate to your court paperwork. Now, we spoke about A, B, and C. Now, there is another one, Certificate D. Certificate D is when the parties attended mediation, but they have not made a genuine effort. I've never issued a certificate like that. I don't know any. I've spoken to my colleagues. No one ever done it. It's usually considered if parties attended mediation, they engaged in the process, it's already a genuine effort. They could see things from different perspectives, couldn't resolve lots of issues or some issues, but they've already made a genuine effort. So it's quite rare, pretty much non-existent. And there is a Certificate E. Certificate E is where a mediator has to terminate the mediation in the middle of the process. Usually it's because of the parties' behavior or some disclosures. I haven't done one like that. I know my colleagues did when mediation started and it could not be finished because of the issues arise during the mediation process. So mediation had to be terminated. Now, 5 certificates, but remember, very important thing, just because you have a certificate, it doesn't mean you straight away need to go to court unless it's urgent or really need court assistance. Mediation is really powerful and a really useful tool to resolve your disputes. Put your comments in and I'll respond to all of them.